Good morning and welcome to the Tennessee Court of Appeals. We appreciate both of you and your clients agreeing to participate via Zoom. We realize it's probably not the preferred way, but it's the best way that we can hear cases and keep the system working. So that's what we're doing. Before we get started, I want to introduce your panel for this morning. Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Both of you have been to the Court of Appeals before and know our rules and procedures. We will utilize those same rules and procedures as if we were standing in the courtroom today. Essentially, each side gets 15 minutes to make its oral argument. If you're the appellant and you've reserved rebuttal time with Mr. Hibner previously, you'll receive that rebuttal time, and you may reserve up to 5 minutes of rebuttal time. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case, please.
In re Investigation of Wall and Associates, Inc.
And we'll hear from the appellant.
Please the court, Russell Tabor for the appellant, Wall and Associates. On behalf of the appellant, we respectfully request that this court reverse the Chancery Court's order sanctioning Wall and Associates for alleged non-compliance with the request for information, where first, the request for information was legally defective, and second, where the alleged acts of non-compliance were never specified. First, the order was premised on a legally defective request for information. The law does not permit an unlimited investigative scope. And here, that scope was essentially everything that appellant does, which is advertise and provide tax relief services. And that just describes our business. The Chancery Court's alternative formulation did not provide any more information, and that was all of Wall and Associates' deceptive acts and anything related to its deceptive acts. But that, again, it just merely summarizes the gist of the Tennessee Consumer Protection Act. So neither of these descriptions even remotely tells us what the investigation is about. But the Tennessee Supreme Court, in its Shriver decision, held that due process requires this type of request to be sufficiently limited in scope, relevant in purpose, and specific in directive. An RFI that encompasses essentially everything a business does necessarily fails that standard. And that's particularly true, whereas here, the U.S. Congress has expressly authorized companies like Wall and Associates to engage in this type of business when it enacted the Taxpayer Bill of Rights. The scope of the request for information here is much like the impermissible scope in Shriver, which was the Antitrust Division's investigation of the Tennessee liquor industry. And it's unlike the permissible scope from this court's decision in Windsor Tower, which identified the specific alleged violation and the Tennessee Consumer Protection Act provisions implicated. And that matter concerned alleged misrepresentations about the shady side of a particular building. The second legal defect is that the request for information is not supported by a reasonable factual basis, as indeed the state did not even identify an alleged violation of the Tennessee Consumer Protection Act in its request for information, and in fact has not identified an alleged violation in its 4 years of investigation and counting. The Tennessee Consumer Protection Act and due process implicitly require the state to identify the alleged violation in the request for information. Tennessee Code annotated 47-18-106A permits the state to conduct an investigation regarding, quote, the alleged violation, unquote, and to obtain information, quote, relevant to the subject matter of the investigation, unquote. The state's brief at page 15 concedes that due process principles implicitly require disclosing the matter being investigated, which of course makes sense, as otherwise neither the court nor the recipient may begin to assess whether or not the requests are relevant to the subject matter of the investigation, which is precisely the problem we ran into in this case. And this Shriver standard is necessary as a check on executive power, because as the Shriver court warned, given the awesome power inherent in the use of this type of investigative request, if unbridled, that power could be abused. And the state has said it has not determined whether or not Wall & Associates has violated the Tennessee Consumer Protection Act. And that's after 4 years of investigation and hundreds of thousands of dollars in legal expense imposed. And I would refer the court to the quotations on page 9 of our reply brief. The requests here are unduly burdensome and disproportionate. While this court's decision in Windsor Tower was decided almost 40 years ago, before the era of electronic discovery, and presumably involved copying some paper files at minimal expense, here the state has demanded an email search that alone would cost 20 times the combined total amount paid by the 4 complainants identified by the state to Wall & Associates, only 2 of whom were even Tennessee citizens, and all of whom allegedly made complaints 6 or more years ago. And the state has even demanded that Wall & Associates use a search term, an email search term, that the Chancery Court excluded. The state's deficient request for information set the stage for this unreasonable and disproportionate burden inconsistent with due process. Next, the court erred in sanctioning Wall & Associates for not producing documents, when neither the court nor the state has identified even one document that Wall & Associates failed to produce that the Chancery Court ordered it to produce. Well, what did we produce? We produced a day of testimony and over 100,000 pages of documents, including 330 Tennessee customer files, advertisements, emails, training materials, recruiting and hiring documents, templates for working with taxing authorities, pleadings and correspondence regarding other governmental proceedings, and employee lists and contact information. And so with regard to the order in question, there were 2 categories at issue. One was financial information, which referred to tax returns. And the state incredibly claimed that Wall & Associates had not produced tax returns when it had, but the Chancery Court obviated that issue when it clarified in its October 9, 2020 hearing that it had never ordered Wall & Associates to produce tax returns. And the second issue concerned emails. A former lawyer for the state had claimed that Wall & Associates did not produce unspecified emails between its owner and an unidentified vendor. And that allegation was apparently the result of the rampant technical problems the state was having with its document review, as we've explained in our papers. Wall & Associates made more than the, quote, good stab, unquote, that the Chancery Court required of us in locating responsive materials, and certainly did not intentionally violate any order. This appeal implicates a fundamental right, and that is the due process right to be free from the awesome governmental power of an unbridled request for information. That's the right upheld in the Shriver case by the Tennessee Supreme Court. But under the state's view, it may merely assert it has reason to believe a company may violate the Tennessee Consumer Protection Act in some unspecified way, and on that basis, launch an investigation into everything the company does, causing the target to spend years and hundreds of thousands of dollars responding to an investigation that is without a specified basis, a defined scope, or apparently an end. Indeed, the state has focused its investigation apparently on matters having nothing to do with the Tennessee Consumer Protection Act, such as the owner's ex-wife from 25 years ago, and whether he has children from these relationships and others. The conduct of the state's disproportionately expensive and disruptive investigation has created a chilling effect on Wall & Associates business contacts across the country. And incredibly, the state has even targeted Wall & Associates' outside lawyer in Virginia. The unfettered request for information is contrary to the Tennessee Consumer Protection Act and contrary to constitutional due process. So in conclusion, Your Honors, I would say that faced with a nearly unlimited request for information that was not tied to any allegation of misconduct or anything else that would define a scope of investigation, we did our best to comply, including a massive document search that resulted in production of over 100,000 pages, only now to have been sanctioned for non-compliance, even though no one has been able to say in what way we failed to comply. The Chancery Court's order overlooked these fundamental legal defects in the request for information, and thus we respectfully request this court to vacate the order.
Mr. Tabor, let me ask you, in your notice of appeal, you include that February 14, 2019 order. Is that correct?
Yes, Your Honor, that's correct.
Is that in the record? Because in checking the record, I could not find that order as a part of the record. Did you review that record before it was shipped to the clerk's office?
Yes, Your Honor. There were a number of, I believe, 9 or so cases involving this investigation, and the court would enter orders in sometimes in that apply to multiple cases. And I believe in that instance, the courts filed that order in the other case, and then the docket referenced it as well in this case. And so that was an issue too, I think, with some of the state's filings that are at issue in this case. And so this court certainly can take judicial notice of those orders, and particularly as they relate to the matters in this case.
You could also supplement the record to include this order, because that's one of the orders that you're appealing. Is that correct?
Yes, Your Honor. We would certainly be glad to supplement that promptly, Your Honor.
All right.
All right. We'll hear from the appellee.
Thank you, Your Honor. Good morning, and may it please the court. My name is Margaret Siller, and I'm here on behalf of the state of Tennessee, the petitioner appellee in this matter. This case involves a 2017 request for information, or RFI, issued to Wall & Associates by the Attorney General of the state of Tennessee under the Tennessee Consumer Protection Act. After 4 years and 4 court orders, including an order imposing sanctions, Wall has failed to comply with that RFI. Instead, it now comes before this court claiming, first, that the RFI is not valid, and second, that the sanctions imposed by the Chancery Court for its failure to comply were improper. Both of these arguments, which I will address in turn, are meritless. With respect to the validity of the RFI, Wall makes 2 primary assertions. First, that the RFI is overly broad, and second, that the RFI lacked a sufficient factual basis. Both are unfounded. Wall's argument that the RFI is vague misapprehends the statutory requirements of the Tennessee Consumer Protection Act. Under the TCPA, the only requirement that the Attorney General must meet in issuing the RFI is that he has a, quote, reason to believe that a person is engaging in, or will engage in, or has engaged in an unlawful act or practice, or that he has a reason to believe that it would be in the public interest to conduct an investigation into whether such unlawful conduct is occurring. The RFI here explicitly satisfied that requirement, and Wall's arguments to the contrary are unavailing. For example, Wall relies on Shriver, and Source for Public Data, which is CFPB case, two cases where the relevant investigative demands were issued under different statutes with varying statutory requirements. Here, those statutory requirements are not at issue. All that is required under the TCPA is that the Attorney General have the requisite reason to believe. He is not required to identify certain cases or parties or matters at issue as he would be if he had issued this investigative subpoena under the Civil Investigative Demand Statute. Second, despite Wall's contention that the RFI was broad, it's well accepted that the nature of an investigation can be stated generally. This is because it would be nonsensical to require an agency that is investigating whether a violation of law took place, to make out a cause of action at the point of issuance of the subpoena. In fact, the United States Supreme Court has held multiple times that an agency can investigate merely on suspicion that the law is being violated, or even just because it wants assurance that it is not. This is precisely why the TCPA authorizes the Attorney General to issue an RFI in two circumstances. One, if he has the reason to believe unlawful conduct is occurring or has occurred or will occur, or if he has the reason to believe that it's in the public interest to investigate whether the law is being violated. Wall conveniently omits this second prong, the fact that the state can investigate whether the law is being investigated. Rather, it argues that we must identify an alleged violation at the outset of the investigation. This is not only contrary to the statute, but is contrary to all the case law surrounding investigative subpoenas that we have detailed in our briefing. In general, Wall's arguments that the scope of the investigation is vague, or that the Attorney General must identify violations of law at the outset, are simply baseless. Now, in a second attempt to challenge the validity of the RFI, Wall argues that the Attorney General's reason to believe under the TCPA lacked a sufficient factual basis. As an initial matter, the TCPA does not require the Attorney General to provide a factual basis. As noted previously, the Attorney General is only required to represent his reason to believe in the RFI. However, the state acknowledges that in the unpublished Windsor Tower opinion, the court suggested that such a factual basis is necessary. Assuming that to be the case, the state has satisfied its burden. By way of background, when this RFI first came before the Chancery Court, the state submitted a declaration detailing the information it received from another law enforcement agency in Virginia and the complaints that it reviewed from Wall's customers. Based upon that declaration, the court held that there was an adequate factual basis for the RFI's investigation into Wall's provision of tax relief services. Wall has asserted that this factual basis was insufficient because it relied on a minuscule amount of outdated consumer complaints, and that those complaints were from several years ago. However, there's no legal basis for that argument. Wall cannot point to any case law indicating that a certain number of complaints is required, or that the Attorney General's reason to believe expires at some indeterminate time. Now, with respect to the advertising component of the 2017 RFI, the court actually did grant Wall's protective order on that specific prong, subject to an additional showing by the Attorney General. The state made that showing. In fact, the state filed another declaration in November of 2018, detailing Wall's express and implied advertising misrepresentations, and even attaching copies or excerpts of such advertising examples. Upon review of that declaration, the court held in its February 14th, 2019 order that there was a sufficient factual basis for the RFI's examination of Wall's advertising practices. Therefore, while the statute only requires that the Attorney General have the requisite reason to believe, even if the state must demonstrate a factual basis, it has undoubtedly done so here with respect to both aspects of the RFI, Wall's provision of services to customers and its advertising. Before moving on to Wall's second basis for the appeal, the propriety of the sanctions issued against it, it must be noted that Wall, neither in its briefing nor in its oral argument today, does not contest that the RFI complied with the judicially created standards espoused in Morton Salt and adopted by this court in Windsor Tower. That's because the court in this proceeding went through each and every request in the 2017 RFI during the December 2018 hearing, a total of more than 40 requests, and ruled on each and every one of them individually. There is no basis to conclude that those RFI requests did not meet the standards in Windsor Tower. Turning to Wall's second basis for this appeal, that the Chancery Court erred in imposing sanctions for its noncompliance. In making this argument, Wall attempts to shift the burden, claiming that neither the court nor the state identified what Wall failed to produce in response to the RFI. Not only is this incorrect, as we detailed in our briefing, but it really avoids the real issue, the nature and breadth of Wall's noncompliance. The court ordered Wall, first in its February 2019 order, to produce all documents in response to requests for production 7, 17, 20, 21, 23, including emails from 5 identified custodians, and to provide a response to written statement 18. For months after that order, the parties attempted to negotiate search terms. And while they never came to an agreement, Wall did agree to run a hit count on the state's proposed search terms. That hit count returned a total of 700,000 documents. While Wall has attempted to argue that the state is mandating that it use its search terms, which is untrue, the fact of the matter is, when Wall actually produced those emails on May 23rd, 2020, over a year after the court's initial order and after the state had already sought sanctions, Wall produced just 1,228 emails, less than 0.1% of the estimated hit count. While Wall argues today and in its briefing that the minuscule amount that it produced was appropriate in light of the court's statement that it only must make a, quote, good stab at producing responsive documents and that it did its best, that argument simply cannot stand. First, contrary to what Wall's counsel just stated to this court, the state has notified Wall and the Chancery Court that it is aware of multiple emails to and from an advertising vendor where E. Kenneth Wall, the founder of Wall and Associates, and one of the designated 5 custodians approved certain advertisements to run. Those emails are directly responsive to RFP 17 and were not produced. In fact, most of the emails to and from E. Kenneth Wall were not produced until after Wall was sanctioned. Second, after it was sanctioned, Wall produced over 35,000 additional emails in response to RFP 7 and 17, which equates to 30 times the number of emails it produced when it claimed it was satisfying its obligations under the court's orders. This fact illustrates that Wall's representations that it was compliant are just simply not accurate. Finally, despite Wall's acknowledgement in its opening brief that the court ordered a timeframe limitation of January 1st, 2014 to the date of production, to this day, Wall has still failed to comply with that timeframe with respect to each of the requests at issue. In fact, Wall has determined that such a timeframe does not apply to it and that the timeframe ends at the date of the court's order as opposed to the date of production. And for example, Wall has made a lot of mention of the tax returns in response to RFP 23 and written statement 18. While Wall did make a production on the eve of the court's hearing on the motion for sanctions, its response to written statement 18, which dealt with tax revenue, was not only in the incorrect format and without the proper verification, but it was still incomplete. Wall has failed to produce its 2019 or 2020 income derived from Tennessee, even though it repeatedly acknowledges that the court implemented a timeframe from January 1st, 2014 to the date of production. That date of production was May 2020 at the very earliest.
Counsel, let me ask you a question, or a couple of questions. What is the status of this litigation now?
Currently, Your Honor, there were previously about 8 different dockets related to other different RFIs that had been issued to parties in connection with this investigation. And as my opposing counsel noted, some of those are subject to different dockets and some were included in this docket at the very beginning. Many of those have since been closed. There remains a few that are outstanding, namely the state's investigation into Wall's collections attorney and the state's investigation into Atlas Tax Service, which is Wall's sister company that prepares tax preparation services.
The reason I asked the question is I'm trying to figure out as best I can when this all became appealable. At what time, when did this become or achieve the finality that required an appeal?
Your Honor, the court's final judgment in this docket 18606 was not issued until November of 2020 when it ruled on the Attorney General's motion for attorney's fees, which it was the sanction imposed on Wall that we're discussing. In looking back through all of the orders that are at issue at this case and that Wall is appealing, the February 14th, 2019 order left open some certain written statements, Statement 5, and it also left open the possibility for the Attorney General to narrow certain requests or for the parties to come back for disputes. So the subsequent motions on clarification and then motions for sanctions were not final until the November 2020 order on the attorney's fees.
Okay. Thank you.
In sum, Your Honors, Wall is well aware of its non-compliance with the RFI, and its arguments regarding burden have been overruled on multiple bases. It has not satisfied its burden here to overrule the Chancery Court's imposition of sanctions, and those sanctions were proper. In conclusion, not only was the 2017 RFI validly issued, but the court properly sanctioned Wall for failing to comply with it and with the court's orders to that effect. As a result, the judgment of the Chancery Court should be affirmed. Thank you, Your Honor.
So what about that February 2019 order? It should not be a part of this record. Isn't that a part of the appeal here? Yes,
Your Honor. It should be a part of the record. As my opposing counsel noted, it is captioned with both the 18561 and 18606 dockets. However, it was only inadvertently filed in the 18606 docket, a fact that neither of us were aware of until we received the record on appeal in this matter. But we do agree that the court can take judicial notice, and we would also agree to supplement the record if that is the best course of action.
Okay, all right.
All right, we'll hear the rebuttal from the appellant.
Thank you, Your Honors. The state has stated that we do not dispute that the government complied with the Tennessee Consumer Protection Act, and we certainly disagree with that, as indeed, as I stated in our opening argument, the state never identified an alleged violation and still hasn't. Incredibly, after 4 years of investigation, dozens of pages of briefing in this case and this oral argument, we still don't know one alleged violation of the Tennessee Consumer Protection Act or one consumer allegedly harmed. We have spent hundreds and incurred hundreds of thousands of dollars of legal fees defending and responding to an investigation that has an unlimited scope that plainly violates the Tennessee court's decision in Schreiber. Now, the state says, well, Schreiber involved a different statute. It certainly did, but it involved the same Constitution. The state also incorrectly says it has not mandated that we use the state search terms, and that is also incorrect. The state moved to compel us to use those search terms, even though the state knew that the search terms returned a large number of irrelevant documents. In fact, a mountain of irrelevance. The documents returned by the state's proposed search terms would include things like spam email, what Google searches we were running, office equipment, what office equipment we were purchasing, emails about hotel confirmations, and on and on. The information is irrelevant. That's why we asked them, what are you investigating? So please let us know. So if there's an issue, we certainly could happy to address it. And also that would help us define our search in some way to return what you're looking for, but they refused. And so that is the problem here, is now they're saying, well, there are certain emails that you didn't produce, but we won't tell you what they are because it's confidential. And in the world of e-discovery, when you're dealing with enormous amounts of electronically stored information, you have to define the search in some way. Here, their search they wanted was going to cost over $700,000, which was clearly disproportionate to the needs of the case.
Well, let me ask you, Mr. Tabor, in that September 2020 order, didn't the trial court outline what things that Wall failed to respond to in connection with the request for information?
Well, Your Honor, that is, the court did have some language to that effect. We filed a motion to revise, and so I'd point the court to the October 9th, 2020 transcript, where I specifically asked the court, what is it that we did not produce that you're saying we failed to produce? And the court did not identify anything. And so then we asked the state. And so we've worked through that. And so today, for the first time, they're saying we didn't produce later tax returns when that was an issue I asked about over a year ago before we filed the appeal. And so the state should not be able to wait until oral argument on the Court of Appeals to claim that there's some document we didn't produce.
But in the September order, didn't the trial court specifically say that you didn't provide the request for information in regard to requests 7, 17, 20, 21, 23, and 18?
The state did say that, and Your Honor, as we briefed, that was mistaken because the court did not understand that we had produced those documents before the hearing, because the court said, well, we didn't file a supplemental certification. So what we did in our motion to revise is we provided all of the information and laid it out very clearly as to how we had complied with the order. And that's why at the October 9th hearing, I said, Your Honor, what is it that we haven't produced that you're saying we need to produce? And the court said, well, you just need to look and make sure you've complied with the order. And so when neither the court nor the state can identify anything we didn't produce, then we could not have intentionally violated any order.
And let me make sure I understand this. In connection with the hearing in December of 2018, did the trial court review all 40 requests made by the state and make a determination that the things requested were reasonable and consistent with the Tennessee Consumer Protection Act?
Your Honor, yet the court did review each of the requests and modified some of those and allowed some of those subject to modifications. But again, the fundamental problem was that the court was operating in a context where no alleged violation was ever specified. The court said, allowed an investigative scope that concerned literally everything that our company does. And that was the problem, because the court was unable, once you define a scope that's unlimited, then everything becomes relevant. And so that was the problem, the fundamental problem in the case, Your Honor.
And you do agree that the statute mentioned in Shriver is different from the Tennessee Consumer Protection Act, because in Shriver, that statute requires specificity, but the Tennessee Consumer Protection Act doesn't require that, does it?
You're correct, Your Honor, that the statute is different. Now, it's due process that requires the specificity, and the state on page 15 of its brief concedes that due process implicitly requires disclosing the matter being investigated, and that's consistent with TCA 47-18-106A that references the alleged violation. So there has to be an alleged violation. Otherwise, we get into this situation where we're in a never-ending investigative quagmire, Your Honor.
Okay.
All right, thank you, counsel. We appreciate your argument. We'll take this matter under advisement and attempt to render an opinion at the earliest time possible. Again, we appreciate you participating via Zoom. Ms. Tivner, if there's nothing further, you may recess the court till the call to the next case.
This honorable court is now in recess until 11 a.m.
Thank you, counsel. You may leave.
Thank you very much, Your Honors.
Thank you.
Thank you.